one of the issues that I have, well, dealing with this investigation is it's not entirely clear when the parties came to realise that they were being represented by the same solicitor, but I don't think that's the biggest issue in this particular case, because as Michael said, this is one of those matters which snowballed. Things got worse and worse. So the solicitor's acting for both parties. Settlement was scheduled. It didn't go ahead because the purchaser had a lot of problems getting some funding. And so in lieu of settlement, the solicitor drafted a licence agreement which allowed the purchaser to move into the premises and start paying rent. And then settlement was scheduled for a later time. The settlement continued being delayed because the purchaser couldn't get finance, and that, well, it's now obvious that they couldn't get finance because there were issues with providing fraudulent documents to brokers, and and at this stage we're thinking, well, this is getting a bit ugly. But whilst this was during this period, remembering the purchaser has moved into the property and the vendor is still waiting for their money, and the vendor in the meantime has purchased another property, so requires settlement to go through on the first so that she can settle the second. So during that time, the real estate agent rang the solicitor and asked him to call the vendor and tell the vendor that the valuer for the bank is going to contact her to confirm details of the sale, and she should say that her house sold for a higher amount. So the solicitor said...
Is that in order to borrow a higher amount, because the bank would probably only lend 80% of the value of the house?
That's right, that's right. I mean, that's the only benefit that we can see. And so the solicitor said, okay, and contacted the vendor and relayed that conversation to her. I must say he was quite thorough, so he kept very detailed file notes of all these conversations. So he spoke to the vendor, asked her to comply with the real estate agent's request, and she said, okay. So then, of course, the broker requires further material, and in order to back up what everybody was saying, someone needed to provide the contract note which reflected that information. So somewhere along the line, the contract note was altered. Fraudulently, we think. Well, the complainant in this situation, she denies signing or initialing or altering any documents. So she believes it was the solicitor who actually did that, or the real estate agent. Now, that's something that we're yet to determine. So the situation just gets messier and messier. So at this stage, we're now concerned about the conflict, the issues about fraud, dishonesty, and the representations that were made to the broker and the banks. So 4 months after the property was sold, it still hasn't settled, and the purchaser is living in the house, not paying rent. The vendor is accruing penalty interest. She's still trying to settle the property that she purchased, and she's unable to do that. So she's hemorrhaging money, basically. And at this time, a dispute actually arose between the parties that the solicitor was representing. So, as you would all be aware, the rules say that if you are in a situation where you are appropriately acting for two parties and a dispute arises, then you need to cease acting for those parties. So there was absolutely a dispute, but the solicitor did not cease acting for the parties. Now, I'm not sure if he was aware that there are over 3 pages of rules on conflicts of interest and the different situations in where you might find yourself in trouble and where you might not find yourself in trouble.
And is it right, Angela, that the Legal Profession Act is supplemented by conduct rules? They're all on the website, but you've got to understand the rules in the area that you're dealing with, as well as the provisions of the Act. Yeah. And Angela's quoting from the rules.
So when this dispute arose between the two parties, the solicitor served the purchaser with a rescission notice, and well, I'll just describe what the rescission notice looked like. Did
you follow that though? The solicitor who's acting for the vendor serves a rescission notice on the solicitor acting for the purchaser. Have you guessed who that was?
Yeah. So it was actually addressed to the purchaser with the purchaser's details and her legal representatives, being himself, rescission notice, and signed by himself, and stamped and again signed by himself. But in this situation, he did make those decisions, and it's quite unfortunate, but he was still believing, I guess, that he was superhuman, as you know, and that's a big issue that we come across, and he thought that he could settle this matter, and the vendor wanted the house to settle. The purchaser wanted to purchase the house, and they continued instructing the solicitor, so the solicitor continued acting for both parties. Now, somewhere along the lines, the solicitor forgot that he is the solicitor, and he has duties and has obligations, and despite what you're instructed to do, it's your role as a solicitor to manage those expectations and let your clients know what you can and can't do, and that was absent here. So the vendor, again, continuing to instruct him to settle. Yes, they've issued a rescission notice, but she's changed her mind. She wants the property to settle, so the rescission notice expires. 6 months after the house has sold, so this is going on for a very long time, the vendor has had enough, and she has given a deadline. Settlement has to go through on this date, otherwise we're rescinding the contract. We're going to put an end to the licence agreement as well, remembering that's still on foot. And so the settlement didn't go ahead, and the practitioner served the purchaser with a notice of termination of the licence agreement, still acting for both parties, and the notice of termination is addressed to the purchaser and her legal representatives, signed by the vendor and her legal representatives, all addressed to himself.
We don't always get lollies like this that are just laid out.
This was too good to pass up. We had to share it with you. So now, unfortunately, the purchasers, they refuse to leave the property at this stage, so it's just getting worse and worse and worse. So the practitioner issued a notice to vacate against the purchasers, still acting for both parties. It finally settled after almost 7 months, and all the parties together entered into a deed of agreement whereby the purchasers agreed to pay the outstanding, the monies that were owed to the vendor, that being penalty interest, the rent arrears, and they agreed to pay in instalments. Nobody, unfortunately, was told to get independent legal advice. Nobody even knew that that was an option that was available to them. But the settlement did go ahead, and unfortunately the purchasers didn't pay up as per the deed of agreement, and after settlement the solicitor, I guess, thinks that he now thinks that he's not acting for the purchaser because the settlement's gone ahead. He's issued a bill to both parties, they've both paid him, and now he is just acting for the vendor and decides to issue a complaint in the magistrate's court against the purchaser for the monies that are owing to the vendor under the deed of agreement. So the vendor is owed about $31,000, and although we can't attribute that financial loss to the practitioner's actions, it's still of some concern, and now we're still investigating the matter. It's almost finished, but these lovely matters have just recently arisen, and I think I'd just like to share with you some of the practitioner's comments about his view on the conflict. He, as I said, he continued acting for both parties because they continued to instruct him. He agrees that he was 100% unprofessional, but doesn't think that there was anything improper in his actions. And even if the vendor had a QC acting for her, she would have achieved the same result. So I think that's in line with that superhuman
mythology.
Yeah. But it's also likely that the Real Estate Institute of Victoria will be notified about that particular matter, because the real estate agents actions have, they've raised some eyebrows too. So.
And so the case is a sweet example of how deeply you can get into what is now a major misconduct investigation involving much more than conflict of interest, involving making some terrible decisions about forging documents, conspiring with a real estate agent to lie to a bank about whether the house was sold for X or Y dollars. And I know it's a glaring example, which you would also do. We would know to do that. But you can, like a frog in water, not realise that it's getting hotter and hotter and hotter. Every practitioner is in that same situation. I've been in it myself. Conflicts of interest can catch you, and one of the important things is to be confident enough to say to your client, I recommend you get independent legal advice. I know it's a hard thing to do because it's almost an admission that you're guilty of some act of negligence. But it's an extraordinarily valuable insurance policy to avoid getting trapped by things that you can't see, which is what a conflict of interest issue is about. You become blinded by other aspects of your obligations, your loyalty to the real estate agent, your belief that you're so competent at both left and right hand that you can do it at the one time, despite the fact that the problem gets trickier and trickier and trickier. And you fool yourself into thinking that because your poor old customers are still delivering instructions to you, that they don't think you're in a conflict of interest, so therefore you couldn't be in a conflict of interest. So all of this self-talk and this self-belief that you're so competent, you've done this so many times that you are almost superhuman and you'll be able to pull off some miraculous outcome, is a major error that will cause tears before bedtime. Now, Sarah, you're going to talk about no-win, no-fee agreements.
I just wanted to talk about an example that I've got at the moment. So we haven't got any outcome yet, but I thought it was relevant to you guys today. This complaint came in, and the scenario is that there was a no-win, no-fee agreement in place.
Can you hear Sarah up the back? Yep.
Yes, okay. An offer came in from the defendant, and the advice provided by the lawyer was to the client that he should accept that offer. It was a good offer and he should accept it. The client chose to not accept that advice and wanted to forge on to trial. So this took the client outside the boundaries of the no-win, no-fee or the conditional cost agreement, as we see it. And the solicitor then demanded some money up front in terms of the work that would be required to prepare for the upcoming trial. Further on down the track, the client then became dissatisfied with the service he was getting from the lawyer and lodged a complaint about those sort of service-related issues. And during the investigation of that complaint, it's become revealed, we're still investigating it, but at the moment it looks like the $11,000 which was paid by the client as the upfront costs, there was no bill rendered for that money. I don't even know how he came up with the figure. The client doesn't seem to know either, but certainly the money was paid. There's a question about receipts as well, but certainly the money was paid and there's no bill on file at this stage. So I thought it was interesting because it sort of shows perhaps how somebody can be extremely well organised in relation to their no-win, no-fee matters, which would be the bulk of their work. And then when something pushes the case outside those parameters, their processes just fell down, and he didn't seem to have in place the type of process that he needed to organise the bill, come up with the figure, render the bill, receipt the money properly. Seems pretty straightforward, but sorry, have you got a question? Yep.
Was that money supposed to be for work already done, or was it supposed to be in anticipation of forward costs?
The question from the back was the money for work already done, or was it for costs to be incurred in the future?
I haven't actually got an answer to that from the lawyer yet, that question, and the client's a bit muddled about it too, so I'm expecting it's maybe part and part. So perhaps the lawyer said, you've been pushed outside the no-win, no-fee, so now I need you to pay for all the work I've done to date, plus in anticipation of work in preparation for trial, and put some money in trust in relation to counsel's fees and things like that.